In Silicon Valley's tech startup culture, the old saying that it's better to ask for forgiveness than for permission reigns supreme. These companies will intentionally rush to build their products quickly before anyone has the chance to question it, in the hopes that the company will become too big and ingrained into society for them to face any real consequences from regulators later on. This is a tried and true Silicon Valley strategy that's been successfully executed by major companies like Uber and Airbnb. But in artificial intelligence's case, these questions are coming from other companies and regulators now, and there's perhaps no bigger question than that of copyright law. The New York Times recently announced a major lawsuit against Microsoft and OpenAI, the makers of ChatGPT, for copyright infringement, and it's widely expected to be a landmark copyright case against AI. The Times claims that Microsoft and OpenAI exploited its content without permission in order to build their AI models, saying that Times journalism is the work of thousands of journalists, whose employment costs hundreds of millions of dollars per year, and that Microsoft and OpenAI have effectively avoided spending the billions of dollars that the Times invested in creating that work by taking it without permission or compensation. Because of this, the Times is seeking damages in their lawsuit, in addition to asking the court to stop the tech companies from using its content and to destroy the datasets that include the Times' work. The crux of AI copyright issues like this centers around how AI models are built. Data is the lifeblood of AI. In order for an AI model to be built and trained, countless articles, images, and other datasets are fed to the AI model as materials that can be referenced in the future. The amount of data required to build an artificial intelligence model is massive, so tech companies decide to create automated programs that scan the internet and scrape data off websites to add to the company's AI models. In other words, AI systems are being built on a massive amount of articles and images that other people and copyright holders made. The only reason AI models like ChatGPT are able to write and answer questions in a way that seems human-like is because it was fed insane amounts of data in the form of articles that were created by real human authors. It's then able to synthesize all of these articles in its dataset to help it answer questions and prompts that are given to it. This means that leading artificial intelligence companies like OpenAI essentially built their products off of content from publishers like the New York Times without permission or compensation. The many copyright questions that this brings up are pretty glaring. It's not clear whether the way AI companies have built their platforms is even legal in the first place. They may very well be violating copyright law on a massive scale here by using all of this data without any sort of licensing or permission at all. Tech companies like OpenAI have tried to argue that their use of content falls under and is protected by fair use doctrine, which allows for copyrighted material to be used without permission in certain circumstances. The four criteria that are normally used to determine whether something is protected by fair use are the purpose and character of the use, the nature of the copyrighted work, the amount of copyrighted material used in relation to the copyrighted work as a whole, and finally, the effect of the use upon the potential market for or value of the copyrighted work itself. And it can be argued that artificial intelligence models violate all four of these principles of fair use pretty consistently. The first principle, which evaluates the purpose and character of the use, tends to favor nonprofit educational uses of copyrighted works, which are more likely to be protected by fair use doctrine. On the other hand, commercial uses of copyrighted works in order to make a profit are generally not supported by fair use. And since AI companies like OpenAI are ultimately looking to monetize their products and to make money off of other people's work, it's less likely that their use of copyrighted works is protected by fair use. In addition, this principle is often concerned with whether the use of the copyrighted material is transformative in any way. If the use modifies or adds some new form of expression to the copyrighted material, it's more likely to be considered transformative and be protected by fair use doctrine. On the other hand, if it merely copies the original work, it is more likely to be found to violate fair use and copyright law. Proponents of generative AI argue that the tools are transformative, while critics claim that the tools often copy existing works nearly verbatim. The second principle of fair use looks at the nature of the copyrighted work itself. This principle is most concerned with allowing fair use of copyrighted material from factual works, as opposed to creative works of fiction, which are less likely to be protected by fair use. For example, someone using Star Wars as intellectual property in a fictional work is less likely to be protected by fair use than someone writing a non-fiction article that references part of a copyrighted work. While AI models certainly use and reference a lot of non-fictional works that are more likely to be protected by fair use, they also use and reference many fictional works as well. For example, it's not difficult to ask ChatGPT to write the script for an original Star Wars movie and watch the model generate a script using tons of copyrighted material from that fictional universe. This use of data by AI companies could very easily be argued to violate fair use. The third principle of fair use looks at how much of the copyrighted material is used compared to the copyrighted work as a whole. The basic idea is that if you were to quote a small sentence out of a large book, this is more likely to be protected by fair use than if you were to copy 80% of an article. It's arguable that artificial intelligence models often reference and use large parts of a singular work in its dataset when answering a prompt. This is exactly what the New York Times is alleging in its lawsuit, and why it is saying that fair use protection should not apply to Microsoft and OpenAI, since their AI tools can use large chunks of text from Times articles nearly word for word. The fourth and final principle of fair use examines what kind of effect the use will have on the market for the original copyrighted work. Copyright protection aims to protect the ability for the copyright holder to profit from their original work. So if the use of the copyrighted material damages the ability of the copyright holder to profit, it's unlikely that fair use protections will apply. The New York Times lawsuit against Microsoft and OpenAI is also making this argument by alleging that these AI tools are using their copyrighted material and diverting traffic that would normally go to the New York Times and generate revenue for the company. So while tech companies are trying to argue that their use of articles, images, and other copyrighted works is protected by fair use, there seems to be quite a few legal holes in their argument. The landscape of copyright law and artificial intelligence is a minefield right now, with many unanswered questions from all different angles. With AI use continuing to grow, and ChatGPT having over 100 million weekly users, these copyright questions will need to be decided in court soon, and these decisions could have massive implications for the future of artificial intelligence and copyright law as a whole. But be sure to let me know your thoughts on AI and copyright law in the comments below. And make sure to subscribe to the channel for more finance and business content. Thanks.